statements be agreed to, and I call the Honourable Member for Hotham.
Thank you, Deputy Speaker, and it's a pleasure today to make a contribution to the debate about the Telecommunications, Interception and Access Amendment Bill, being known in the community as the data retention legislation. What I want to do today with this opportunity is explain why I am supporting the legislation, and I'll say that I'm doing so with a great deal of thought and reflection, because the truth is that legislation like this raises some very difficult and important questions for us as a parliament, and I think for the Australian community. We're being asked constantly, as technology improves and as our world changes, to make difficult trade-offs between privacy and civil liberties and the use of data which is now routinely collected about us and our online activities. I think for those who are listening in the gallery, for those who are watching at home, I would just ask all of you to greet anyone who is putting this forward, who is putting the debate about this legislation forward as a kind of ridiculously obvious point or question on one side or the other, with a degree of caution, because the truth is that I think anyone who shares broadly Australian values, who has looked at this legislation, who has understood the issues, and who has read the parliamentary report that looked into the detail of the legislation would agree that it's complex, but I believe the legislation before us does strike the right balance, and I'll explain in detail why I have that view. I want to start this conversation where it ought to begin, not with wildly overstated claims, but with an understanding of the situation about data retention today. And the first important point to note here is what data is under this legislation that we're debating today. It is not detailed information about emails that you send and the content of those emails. The data that is being defined under this legislation is quite tightly defined, and it is about the fact of communications, the fact that they occurred. It is not about the data that was contained in those communications. And I think of the confusions about this bill, this is really where we've seen a lot of discussion and debate, and I want people to be clear about that. So, for example, with mobile phone communications, the data that will be retained under this legislation, should it pass the parliament, is the fact that a person made a call, who the call was to and the time of that call. There's no audio recording or text recording of the call. For online communications, for example, email content will not be kept, but the time that you logged onto the internet and logged off again is the sort of data that will be retained. Now, there's a second important point to note about this, which is this data being retained at the moment? And what we know is that the retaining of this such data, and in fact quite more volumes and more detailed elements of data, are being retained by some telecommunications companies but not by others. And what we see with the current regulatory regime around data retention is that both the retention of data and the access of the data are not being well regulated. We do not have a law which is kept up to date with the ability of telecommunications companies to keep this data. So what we have, for example, is some telecommunications companies in Australia keeping this data for 7 years, and others who are saying that they don't want to keep it for longer than a few weeks. So the purpose of this law is to clarify what are the obligations on telecommunications companies to retain data. And I think when you understand the situation as it is today, this very hazy and quite poorly regulated or unregulated in other respects nature of this environment, you see that the best thing we can do is have a discussion as a community about what principles we should apply to these decisions and then create a new regulatory environment for it. Something else I think is important to note is the access. So I've talked a little bit about the retaining of the data by different telecommunications companies, but what we also have learned through this process is that the access to this data is not well regulated. So there are some 80 bodies that are able to request access to telecommunications data, and this includes organisations like local councils and the RSPCA, who are using this data for reasons that I think this parliament has come to the view are not appropriate for this type of monitoring of people's online behaviour. Now, what we also know is that over the last financial year, so 2012 to 2013, there were 331,000 authorisations for different organisations to use telecommunications data, which resulted in almost 550,000 exclosures of telecommunications data. So in this kind of broadly unregulated or poorly regulated environment, 500,000 records were accessed. And I think just that fact alone, Deputy Speaker, illustrates a very clear need for us to tighten up what is going on out there in the world of data retention. Now, I think it's also an important place to start in this conversation talking about the other values. So obviously there's this issues of being an unregulated environment, but what we've heard from the Australian community, I think quite rightly, is that there are civil liberties concerns with how the data is being regulated and accessed at the moment. We know that privacy is an important right of ordinary Australians, and as a starting point we should say that no one should have access to anything that anyone does in their personal lives unless there's some other countervailing principle that we're weighing against it. Privacy is not just important because it's a private right, but of course we know that privacy is critical to the functioning of our democracy. Journalists need to be able to protect themselves and protect their sources. We know that activists and dissidents have perfectly entitled to organise against, to criticise security agencies and other sorts of things. And I very much respect those things, and they must be protected. So this is what we're balancing against the need to potentially access this data. So from that starting point, we've got these very valuable private rights and civil liberties. So we need to understand whether there is a clear need in that case for those types of principles to be balanced against another need. So should the right to privacy be modified in this instance? I think that the PJCIS, which looked at this bill in an incredible amount of detail, it has an excellent chapter on this very question, and I'd really encourage those in the community who have shown an interest in this issue to have a look at the chapter. What we know is that telecommunications are creating new types of crimes, and they're also creating a means for us to resolve very old types of crimes. And we've seen that very much in recent criminal investigations and criminal activity of recent years. So we know, for example, that data retention can be an essential tool in fighting online pedophilia and online sex crimes. We know that terrorism is often organised online, so there's obviously going to be an element of metadata being used to resolve those. But also, and I note the member for Melbourne Ports raised the example of Jill Maher and the woman in Melbourne who was very tragically killed. And we know that metadata was essential in tracking down the person who committed that crime. I know that the member for Blaxland also talked in his speech on this subject about the fact that it's become very routine now when someone is found to have committed a crime. One of the first things that police will want to do is go back through and work out who that person most recently spoke to and try to piece together elements. So I think there's very clear and very obvious needs for anyone who knows anything about how police pursue crimes these days that indicate that there is a need here. And in the submissions to the inquiry into the bill, we saw very clearly that there are a wide range of people who acknowledge this need to curtail the right to privacy in order to assist us in fighting crime. So I don't want to overstate that. There are lots of people, of course, who don't believe that there's any need to make many interventions, but there are lots of people who thought there are. So, for example, Professor Gillian Triggs, who is the President of the Australian Human Rights Commission, she talked in her submission about the need to update the law to reflect the fact that there is an obvious new tool to fight crime, and that this is a good reason in some instances to curtail the right to privacy. Even Timothy Pilgrim, who is the Australian Privacy Commissioner, talked in his submission about the fact that the right to privacy is not absolute and that he sees that there are some clear needs to curtail that right, given what we know about the importance of metadata in fighting crime. So from my point of view, reading some of these submissions has helped me come to the view that it is very important that we try to better regulate this area, and that access to metadata does need to be allowed under some conditions. Now, some of the other speakers have talked about the role that Labor has played in making this legislation into what we believe is a good and decent piece of legislation. Where we started on this bill, I think we've had broad acknowledgement was not a great place to start. I think we even saw that from the people that proposed the bill in the House, that there was a real need for the Parliament to look closely at the legislation and to improve on it. And I'm actually very proud of the work that Labor has done through the parliamentary process. There are some in the community who would have liked to see a sort of stand-up fight on this one a little bit, but we actually see that this is a very serious issue. It needs serious consideration, and that's why we have used the Parliament to make this bill into something that we feel that it strikes the appropriate balance. So I'd like to explain just briefly some of the things that Labor has pushed to change in this bill that I believe have allowed it to strike that right balance. The first one of those is that under the legislation we're debating now, the definition of data is actually included in the substantive legislation itself. That sounds very technical, but really what it means is under the previous version of this, the Attorney-General could, through regulation, change the definition of data. This is important because the definition of data, as I've explained, does not include things like the list of websites that you visited. It doesn't include things like the text of email. And we believe that should be enshrined in legislation, because if there is anyone in Australia who wants to have a discussion about whether that should change, we believe that that discussion should take place here in this chamber, and that we should all get to have a say in it, rather than allowing the Attorney-General to have the right to make that change on his own. The second is limiting the list of agencies who can access that data. Again, under the previous version, this was not in the substantive bill. So what we have said is that if the government of the day wishes to make a change to the agencies that are allowed to access metadata under the legislation, they will now have to come back into the Parliament to do that, and the Attorney-General is not going to be allowed to add agencies as he or she sees fit. The third thing we have done, which I think is tremendously important, is allowed a provision in the legislation so that individuals can now access their own metadata. And I think if we are going to infringe on the right to privacy to a degree, I think it's only fair that people understand what it is that other agencies might have access to. So we've made sure that that's enshrined in the legislation. Another point is about how this data is protected. So because of Labor's actions, the data that is being retained by telecommunications companies will now be encrypted. We've added an oversight mechanism into the bill, so after 2 years of operation, the PJCIS, which is the committee that considered this legislation in detail, will have the chance to go through and look at how it's been operating, consider how the data has been accessed and whether the use of such data is appropriate. So to all of those in the Australian community who have a strong view about how this legislation has panned out and the version that's gone to the Parliament, I just say to you, you will get another chance to talk about this when we see in practice how the legislation is used and if there are any improvements to it. Another issue that I would just mention is that through the committee process, Labor was able to ensure that metadata can only now be accessed for criminal matters. And this is quite important, Deputy Speaker, because, as I've said, it's been difficult to strike that right balance between the right to privacy and the benefits in crime fighting that we see through the use of metadata. And we believe that the right to privacy should only be infringed to this degree when there are criminal matters at stake. So, for example, this idea about the Game of Thrones problems, so people were concerned that online piracy might be apprehended through this process. Because of Labor's intervention, that's not what this legislation is about. We're not trying to oversee people's activities to that degree, but where there is a criminal matter to be answered and a criminal matter to be considered, we believe it's fair that the right to privacy be curtailed in this instance. I don't want to state that this is a perfect piece of legislation, and I hope that the remarks that I've made give the indication that we've thought about it and there are remaining issues. The way that the legislation treats journalists is a remaining issue. That was not an issue on which the committee process could reach an agreement. Labor has pushed this very hard, and we're continuing to push very hard on this. And those who have been following the debate closely will know that Bill Shorten, the member for Maribyrnong and the Leader of the Opposition, is continuing to push this with the Prime Minister, and I hope to see that matter resolved. I just also mentioned that we shouldn't see this piece of legislation in isolation. Something else that the Labor Party is interested in pursuing is looking, as we give security agencies more powers, into how we can ensure that there is appropriate parliamentary oversight for those different agencies. and that's something that Labor will be pursuing in the coming months. So, Deputy Speaker, I'm pleased to support the bill, which I believe strikes the right balance, and thank you for the chance to make comments.
Thank you.